Welcome to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond.
Hello and welcome to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond with Evan Simonson of Clark Law Group. They specialize in auto collisions, motorcycle crashes, workplace accidents, and personal injury law, and they are dedicated to helping clients every step of the way. My name is Kevin Rosenquist, and today's episode is all about slip and fall cases. Evan, so good to see you. Thanks for being here.
Thanks for having me on.
So what would you say are the most common causes of slip and fall or trip and fall accidents in Las Vegas each year?
The root cause is usually always the same thing. Somebody spilled or left something on the floorway or on the ground, and the property, whoever owns that area, just didn't catch it, didn't pick it up, didn't clean it.
Seems simple enough.
It's as simple as that. Somebody accidentally left something out there, spilled a drink, dropped something out of a cart or something of that nature, and whoever is in charge of the area just didn't get it cleaned up.
Yeah, you guys don't have the same problem that sometimes we here in Colorado have with snow and ice and stuff like that.
Yeah, the only other common one that we have is the casinos. Of course, people go out and use the pools, and then they come back in and drip water on the floor as they leave the pool area. And of course, all those casinos have high gloss, marble tile type flooring. So similar, not rain or snow, but the water comes in from outside. Somebody coming through a few minutes later doesn't see it. Yeah,
understood. Yeah, I've definitely seen that before. How does property owner liability factor into slip and fall and trip and fall cases?
Every property owner has a duty to make sure that their property is reasonably safe. And that term reasonable is always vague and not everyone can kind of follow it and track it. But certainly if, for example, if you're following directly behind somebody who tracks water in because they just left a pool and they walk into the casino, you walk by 30 seconds later and slip and fall. There's only so much that a property owner can do, right? But the flip side of that is, somebody spills a drink and it sits on the floor for 20 minutes or 30 minutes before somebody then walks through and slips in and falls and hurts themselves. The property owner has to do something to try to make sure that their floors are clean, right? Most people come to Vegas, they don't notice this, but there's porters walking around the floor constantly. And usually they get through at every square foot of the main floor within every 10 to 15 minutes or so, just to make sure in case somebody spilled a drink. Drinks are flowing here in the casinos, and so things spill. And you need to make sure that somebody at least has eyes on that area every 10 minutes or so, just to try to get it mopped up or wiped up, or at least a sign out to indicate that it's wet.
What do victims need to do to prove or to establish negligence?
So the number one thing on a slip and fall, the number one thing you can do if you're in a property, and I use the term loosely, but if you're in a business of some kind, it's really important to make sure that you get an incident report filed with the company. A lot of times people are embarrassed that they fell in the first place. Even though it wasn't their fault, they slipped in something they didn't see. They tend to get embarrassed and just, oh no, I'm fine, and just try to get out the door and go home. But it's important that you do and that you make an incident report. Number one, it puts the business on notice that an injury actually occurred, and that requires them to maintain and retain evidence that they have, whether that be surveillance video, get statements from anybody who cleaned it up, get a statement from somebody who might have seen it happen, so that that you can later on establish that it actually did occur. I've seen it happen where there was no incident report and the business came in and just denied that anything had ever happened because there was no way to prove it had happened in the first place.
Yeah. And what are the common challenges faced in trip and fall cases, and how do you overcome these hurdles when you're representing clients?
One of the most common ones is, I guess I can tell it through telling a story of a trial that I was in a few years back. In Nevada, the jurors are allowed to ask questions of witnesses, not directly. They write them down and send them to the judge, and the judge and counsel decide whether or not to ask the witness. And I had a slip and fall at a business here in Las Vegas. I was not lead counsel, but we had an expert witness on the stand who was a human factors discussing whether or not what goes into somebody falling. One of the jurors had sent in a question that says, when you walk into a business, does your common sense go out the window? And what he was asking is, shouldn't you still be aware of your surroundings, right? Common sense says that you still need to sort of watch where you're going, right? You can't just blindly walk into things that are on the floor, walk into a huge wet spot. That's usually the most common hurdle to overcome is where was this person's common sense? They should have seen this on the floor. Depends on the situation, how you get around it. One of the more common ones is a spill, a slip and fall in something that had spilled on the ground, a liquid of some kind. It almost doesn't matter what the liquid is. When it's spilled on the floor and it spreads, it becomes harder to see, particularly on the tile type flooring that most of the casinos use, because it's intentionally set up to look high gloss in the first place. Old liquid just adds to that glossy nature of the tile. And so you can kind of attack it from the perspective of they couldn't see it. They weren't, the entire situation is set up for them to not see it. Another aspect of that is when you walk into the casinos, everything is eye level and up. You see all the signs are up above you. You see people sitting at machines, they're playing. It's intended to draw your eyes up into the melee, so to speak, the action in the casino. So you're not looking down at what's going on the floor. So if you can bring in that kind of evidence to show that there was no way this person would have seen it, or that a normal person would have seen it unless they were looking straight down at their feet. And even then they might not have, because it's clear water or it's a clear-ish substance on top of a high gloss floor. Those are kind of some of the ways that we get that we can kind of counteract that hurdle.
And what kind of evidence do you try to put together to prove negligence, as well as the severity of an injury in a slip and fall case?
So as far as the negligence, we first thing we try to do is collect any incident report. Like I said, that's one of the first things that everyone needs to make sure they do. Fill out an incident report. Even if you don't feel that you're injured, doing that incident report at least makes a record of the injury. If you don't do that, even if an employee comes over to you and talks to you, they're not going to go back and do it on their own. So we try to collect that. We also look to get any surveillance video of the area. The casinos obviously have multiple cameras throughout the casino. And particularly if we can get video of the fall itself, we try to collect videos that starts an hour or so before the incident up through an hour after, just to be able to see kind of what was happening around that time. I generally prefer to get 2 or 3 hours before the incident, because I can then look to see if those porters were going through that area every 10 or 15 minutes. Sometimes there's a shift change, or they get caught up doing one thing in another part of the casino and they can't get through that area. And so you may see on a video a spill happen and not a single employee walks by for 35, 40 minutes, and then someone comes through and slips. Now there's a problem, because that should have been discovered sooner. Or, as has happened to me, you get a video where somebody spills something on the floor and you actually have employees walking by, looking directly at the spill and just moving on, continuing on as if nothing was there.
Yeah.
Those are the kinds of things that really help to drive, to show that there was some negligence here on the part of the business itself. As far as the injuries, we collect all of the doctor's records for anybody that they've seen for treatment. We try to make sure that those doctor's notes have a causation opinion, because, we've all led lives prior to these incidents. And so some of us have prior injuries, and some of us everyone's back is degrading all the time. So if you have, those of us that are a little bit older know that all too well every day, right? And
Right.
So if you have a prior injury, we want to make sure that the doctor that you go and see is saying, well, the injuries that I'm seeing today, maybe they're different than the injuries I saw with you the last time that I met with you, or if I never met with you before, these are the type of injuries that can occur from this type of incident. And so based on what I'm seeing and the history that you've presented to me, I would say that the injuries are causally related to this incident.
Mm-hmm. We talked a little bit before, joking around, about weather out there is different than where I live. But when you do have weather, if there's ever any conditions or hazardous surfaces because of something that happens regarding weather, can a property owner be held liable still?
Yeah, and there's actually, we've been using the term slip and fall and trip and fall, but there's a third category that does come up occasionally, and it's called a misstep and fall. And where these usually happen is they're largely weather related. The times that I've usually seen them is you have a property that's been around for a long time, and the heat in Las Vegas just does damage to the ground. I mean, eventually it breaks down, and so you'll end up with a parking lot that has a bunch of potholes in it. Somebody will come along and, not looking down at their feet, they step in a pothole and they end up with, severe sprain to their ankle, or, sometimes even worse, knee injuries, hip injuries, depending on how bad the fall is. And the property owner is liable for that, because again, the term reasonable always comes in personal injury law. was it reasonable for them to leave these potholes for however long they've been there? I had a case that we ended up resolving where the property owner, we got records from the property owner that showed that they had just started for the first time ever repaving one portion of the parking lot. That shows that they knew there was a problem, and so they had gotten somebody to repave this and fix these potholes. But that doesn't mean that they're not liable for the other potholes that, in the parts that weren't being repaved or resurfaced.
Good point. Yeah, like they knew they were there, then especially they recognized it was a problem.
Absolutely. And not only that, but they recognized it was their problem.
Right. That's true too. Very important. Yeah. See, that's why you're the lawyer. That term reasonable, it's very interesting, because as for a business owner, there's only so much you can keep up with and you're trying your best and all that, but is the jury able to, if it goes to a jury, is the jury able to make their own definition of what reasonable is, or do you try to define that before you get that far?
So there are jury instructions that go directly to that. And so when a person is sat as a juror in a trial, one of the things that they are told is you can bring in all of your own common sense knowledge that you have from just everyday life. And so the term gets thrown around a lot, and usually it's defined as part of these jury instructions that says, what would a reasonable average human being expect under the circumstances? Everybody's definition of that is going to be a little bit different, but the theory, I believe, is that as an aggregate, we all kind of human beings in a certain community understand what that community might think of as reasonable. So if you have, 8 or 10 jurors on a case and 6 of them have one understanding that's very similar and the other couple of them don't, that kind of helps to tell those other 2, maybe their definition of reasonable is not what the community feels. I've never been on a jury myself, so I don't know exactly how that part happens in the jury room, but in the deliberation.
I haven't either.
But I think that that's sort of the theory, is that when you put 6 or 8 or 10 people in a room, their mutual understanding is what would be deemed a reasonable standard.
Okay. And can you explain the comparative fault rule in Nevada and how that affects the outcome of these cases?
It's pretty much a math-based situation. If you go in front of a jury and you plead your case, and then the defense pleads their case, and they come back and they say, yes, the defendant was at fault. In this case, the slip and fall, the property owner was at fault. However, we think that the plaintiff was, they should have been paying a little more attention. So we're going to attribute 10% of the total fault to that plaintiff, and we're going to award, just use round numbers, we'll say $100,000. We're going to award them $100,000 for this claim, but 10% fault to the plaintiff. That 10% reduces that $100,000 by 10%. So they would recover $90,000 on that.
Oh, okay. Well, that's actually a lot simpler than I thought that was going to be.
It's very simple. The only kind of confusion comes in at the 50% mark. You have to establish that the property owner, the defendant in any case, was more than 50% at fault. That can be the slimmest of margins. I don't imagine that you'd ever see a jury rule that somebody was 50.000000 ad infinitum, 1 at fault. Usually it would probably be more like 51% or 50.1% at fault, something like that. But you have to establish that they were more than 50% at fault, and then they're deemed liable.
So that's interesting. So that would probably fall in a situation where maybe the jury was like, he probably should have known or should have seen it, but he did fall, so we should award him something. Is that, because that's surprising? Like, if you're that close, that's got to be, that'd be an interesting case.
Yeah. So, I'll tell you kind of a brief anecdote. I had a case early on in my career. Again, I think it's actually the same case I mentioned earlier, where ultimately the plaintiff, my client, when she fell, she knocked over one of those 3-foot tall slippery when wet signs. And so, of course, the jury comes in and they say, well, there was a sign there telling her that this area might be slippery. How did she slip and fall? And so at the end of the day, they determined that for many other factors, the business was still largely at fault for this. I can certainly envision a situation like you're saying, where they knock over, the combination of the two. Somebody knocks over a slippery when wet sign, and you say, well, they should have probably known not to walk there because of that. But what are the other factors that maybe leave that business owner just a little bit more at fault? For example, maybe there was a big spill and they stuck this sign right in the middle of it, and it kept spreading, and they just never went and mopped it up. And now, okay, maybe they shouldn't have walked down the aisle of that store because of the signs, but the flip side of that is the business owner also should have cleaned it up. And had they done their job and cleaned it up, or prevented anybody from walking down that aisle, this would have never happened.
Yeah, just a sign is, sure, it's good to have that there, but you still got to clean the mess up. You can't just put a sign over the mess or the liquid and just be like, well, there you go. Now I'm off the hook.
Absolutely. And our expert in that case said it perfectly. He said, when you're driving on the road and you see construction, do they put the cones right in the middle of the construction zone to keep you out of it? Or do they put it, a mile before so you get out of the lane so you don't drive into it?
Right. So you don't go down there. Yeah.
Exactly.
Yeah. That's a really good point too. Cause yeah, you'd avoid, it's one thing, because again, being here where I am, you can put all the signs out you want that that ice is slippery outside. Doesn't mean you're not going to be doing a little dance when you go over it, because it's still slippery. So yeah, taking care of it is important, more important than just alerting that it's there.
Absolutely. That's the biggest issue. As I noted at the beginning, the most common cause is somebody spilling or dropping or leaving something out and it not getting cleaned up. Right. That's kind of the tail end of that. People spill things, people drop things, happens all the time. But a business owner still has to kind of be at least on the lookout. Most every business have what they call sweep logs, which aren't necessarily, although sometimes they are, physically sweeping the area. But a lot of times it's just somebody walking through to make sure that there's nothing on the ground.
Yeah, nothing hazardous. That makes sense. All right. Well, thank you for joining us on Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond with Evan Simonson. To connect with the team, you can head to injuryattorneyvegas.com, and please like and subscribe to our channel and leave us a review. Evan, great having you here. Thanks so much for your time.
Thanks so much for having me on. It was a pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.